My name's Robert Wood. I'm a professor at the Australian Graduate School of Management at the University of New South Wales. I'm also director of the Centre for Ethical Leadership at the University of Melbourne. I'm here today to talk to you about diversity and inclusion and changing work processes in the law. Let me start by maybe just reflecting a little bit on the whole issue of diversity. I think the main pressure in the law seems to be around diversity as it relates to gender. I mean, there's this simple fact in Australia that if you look at female participation in education, we're ranked #1 in the OECD. And then when you look at female participation in the labour market, we're ranked about 35. And so at a national level, we have this large pool of human assets that are grossly underutilised. And this is why you see reports by people like Goldman Sachs saying if we fully utilised educated women, we'd have another $4 billion on the GDP. So the economics of underutilisation of women are quite clear at the national level. They're also quite clear when you look at a profession like law, where women have been, for the last 30 years, have been 50% of graduates, and for approximately that length of time, they've also been 50% of the incoming graduates into the law firms, but they make up considerably less at the more senior level. So this is an asset that's being lost to the profession and to the society. The economics are less clear at the firm level, though I think more firms now are starting to look at what is the cost to them of lost assets. So there's a growing business case. And I mention that because the sort of social justice case, certainly until now, for both women and other people who are underrepresented or are discriminated against, doesn't seem to have won the day. So the business case has become more important. So that's a little bit about, I think, why it's important at one level. The other question that comes up a lot in our dealings with law firms is why, and I think there are several reasons why women aren't progressing through to the senior ranks, as Justice Matthews and others have noted over time. This sort of dwindling, this surge at the bottom, and then a dwindling trickle at the top. And I think one of the reasons is the legacy of the past. The whole power structure is against women. I think a lot of the attitudes of professional senior lawyers is the system is this way because this is the best way to be, and what we're observing is a natural outcome of merit and other selection processes. So I think there's that institutionalised mindset. People believe the system is fair, and if you believe it's fair, then you don't see any real reason to change that. I'd say over the last 3 or 4 years, when my centre's been involved in research and work with law firms, there's been a change in that attitude, both in the LGBTI area and gender and specifically. So there's that. I also think there's something about the law, as it's practiced in Australia, that mitigates against greater access for women and sort of maintains this historical commitment. And I think that is also breaking down. Australian law firms seem to work on it's very much like an academic model. It's an individual fiefdom contracting in which what lawyers seek to do is work out their terms of trade. Partners work out their terms of trade, and then they protect them. And anything that disrupts those, they're likely to fight against. And this is very similar to the academic model, where you want to work out your terms of trade around teaching and research and then just be left alone. I think law firms, where you get my observation is where there's greater practice of team work, partners shift around, they share work, there's just greater flexibility in the work process, so you tend to observe more gender diversity in that situation.
And it's more productive?
It is more productive. Incidentally, the transition costs give you a dip, right, because you have to move from one level of certainty to a new equilibrium, and shifting equilibriums is often difficult. It's probably not the economics that's holding people in the current position as much as a sort of status, because one of the things I've discovered in our research around diversity and inclusion is expertise often mitigates against inclusion and change. There's a sort of there's an inertia that comes with expertise and all the status attached to it. So that when people are heavily vested in the status quo, as experts are, change is just more difficult. It's a bigger hurdle for them to climb over, and and that's partly a function of age. It's partly a function of expertise and experience. I mean, there are other factors in the law that mitigate against attempts for greater diversity. Earlier, one of your other witnesses spoke about this sort of 24/7 being available, high levels of competition. So when the system feels like it's being squeezed to perform, it's very difficult to accommodate change. And so I think new practices always initially oppose a cost. And so unless there's some fairly obvious immediate benefits in terms of competition or performance, they're more easily resisted in the name of, well, we have to keep the ship flying, or ship floating, or the plane flying type of argument. I think one of the other factors that mitigates against change in law firms is the structure of incentives. My understanding is that when people go away on maternity leave, when they come, if you're a partner or on a senior associate or a director level, depending on the terminology, it's often very difficult to reclaim your client base. Now, that's not an issue. I've seen Minter Allison and Cause and others, I've seen examples of where teams interchange, and so women will go off, have children and come back, and because they share clients and they overlap on the servicing of clients, there's a lot of interchangeability that enables people to go away and come back. But if you go away and then come back and you don't have a client base, the time to reclaim that and get your income stream up can be a major challenge for people, I think. So there's all those factors. And then, of course, there's one that we've done a lot of work on, which is unconscious bias. And that's partly a product of these other institutionalised factors and the culture, and I think also the deep commitment to the status quo. And my general impression of lawyers is they're pretty smart people, and so they can see the fallacy of a bias. It's just a question of whether they're willing to do something about it, which is not always the case, because they'll mount the counter arguments as to why the status quo is a better place to be. So they're just some thoughts. I in terms of my observation of the law in Australia, I've dealt with a variety of law firms and spoken to senior partnership groups, and we've looked at workplace flexibility arrangements and a variety of other factors that we can go into. And I think there is a shift on, that change seems to be happening. It certainly has over the last 3 or 4 years that I've been talking to law firms. However, that impression or that observation of mine needs to be juxtaposed against the fact that I do occasionally speak to female partners who say, I've heard it all before and I've seen it all before. I was here 25 years ago struggling, and it doesn't seem to have changed. So hopefully this time it's the real thing, but we'll see.
Thank you. Is your experience or your observations of what is happening out there in terms of gender diversity different when looking at a large firm versus a medium-sized firm versus a small firm, or are there common threads amongst all of those?
Well, it's interesting. I think I think in the senior firm, the large firms, the major firms, the big ones, there's a much larger push to bring about change, okay? And there's, because of the large number of graduates who come in each year, there's just a bigger opportunity. When you've got throughput, turnover, there's bigger opportunities for change. The smaller firms tend to be more idiosyncratic in their responses, and as a result of that, you get a lot more variety. So you get small firms where there's a greater sensitivity to gender issues, and there's more women, and that's largely a function of one or two people in the firm. Whereas in the large law firms, it's more of a collective attitude, and it's a reflection of where the industry's going. But equally, I've seen in small firms just a total indifference to the issue and what's the issue sort of approach, because look, I'm so busy, I'm struggling to get work, I have to be out there, I really don't need this additional burden. But there are, of course, now managing partners, several, one or two mid-level firms, Madison's and others, have female managing partners and have pushed through fairly major initiatives on the back of that.
Are you able to comment on the position in relation to the legal teams within corporations and government, and whether there are any issues in relation to gender that might be relevant to them that would be useful for this inquiry?
Yeah, it's sort of it's interesting. I think the statistics show that females are overrepresented in government and private sector firms, well, particularly in government positions. I think about, if I remember, it was in a Law Society journal, I think about 63% of female solicitors, but that doesn't control for level in government. The private sector is more men, but I don't know whether that talks about corporate or law firms, right? What I do know from talking to corporates is that they view themselves as beneficiary of an exodus of women from law firms into corporate practice, because they offer, while the salaries are sometimes not as high as you're a senior partner, the terms and conditions are better. So, and they see themselves getting highly talented people, females from law firms who come across, who've either just entered the partner level and decided they don't want to do it because the law firm is just not sufficiently accommodating of sort of work-family conflicts, or they're at that senior associate level about to go to partner and they decide, well, no, I don't really want to be in this, and so they move into private practice. It's sort of interesting because, as one of your previous witnesses mentioned, it's very much a buyer's market. So there's quite an interesting phenomena one might think about. If there is a flow of women from law firms into corporate law offices and they're in a buyer's market, one wonders if they mightn't put some provisos, as Westpac and others have done, have started to put provisos on their suppliers around gender strategies and the like.
I guess also such things as equitable briefing.
Yeah,
This might be a broad question, but how does Australia compare in relation to these issues with counterparts in other common law countries?
It's a good question, and one that's not easy to answer. I think gender equity is a much bigger issue in Australia than it is in the UK, for example. It's simply not as front and centre on the agenda, though it has become increasingly with, I think Cameron made some comments about David Cameron, but a few years ago it was less of an issue. It's interesting, some of the global, the UK is one I can speak most about. I think if you look at some other Commonwealth countries like India and Canada, I think Canada the representation is quite good. India, I just don't know what the facts are, but it's quite interesting. One of the phenomena that does seem to affect the numbers of women in some of the large English firms is their different incentive structures. So they have fixed salary scales and they work in team based. So it's not a individual fee for service bonus partnership the equity partnership payout is slightly different, and that factor which allows for more team, so if the incentive structure allows for more team-based approaches and interchangeability of lawyers with clients, senior lawyers with clients, then that allows for greater diversity in the group. And that phenomenon is quite interesting because I can't remember a single lawyer in defending the status quo who hasn't said, look, Bob, I'd love to work more flexibly and I'd love to be able to give more work to my female associates, but the client demands me all the time. I've never met a client who believes that to be true. They'll say, "I would love to have interchangeability. I'd love to be out." And also this idea of being available 24/7. I have a lot of lawyer friends and partners in major law firms, and I sort of laugh about it because they say, "Oh, you wish," because when you talk to, except when there's a big deal going through, right? Most of the time, the person will say, "Oh, well, I called him at 8:00." Last year, in June of last year, that's the only time. Is he still going on about that? So it's. I think there's a bit of a. I think most professions have myths that sustain them, and I think that's one of them. This idea that I have to take calls at all hours and the like. But interestingly, could I just say, I've often heard it mentioned that M&A is one area where, when a deal's running hot, you have to be there all the time. But equally, two of the most effective team-based approaches with large numbers of women, where there's interchangeability, women go off and have children come back, people take holidays by arrangement, some go home at 5 o'clock in the day, 5 o'clock and and then the other times I'll stay until midnight if necessary. Both of those have been M&A teams. And there is some research in the US that shows that M&A teams that have flexible work arrangements and interchangeability are more effective, generate more fees than those that work on this single, the sort of fiefdom, that put one partner in front of the client. And can I just mention, this is an example of how people confuse the transition cost with the long run equilibrium. So if you say to somebody, look, maybe what you need to do is take a junior female partner with you and interchange, and they'll say, well, but then the client doesn't want to pay for two partners. And the question is, well, do they have to pay for two? If you put two, everybody has dead time in their day, right? And so if we put two in front of them, then we can rotate through it over time, and the handoff, so you've got shared information and the like. Now, a lot of people will say, oh, well, then that means we have to bring two people up for speed. But then we start getting into fairly specific conversations about client-specific knowledge versus general knowledge, and anyway, the point is, it seems to work very well in some places, but though it's a question of the transition cost versus the long-run equilibrium issue.
How do you see the Law Society could be helping more here?
Sorry, how do I see the Law Society?
Yeah, playing a role in supporting, providing more support.
Well, I think your charter is very. Is the Law Society the founder of the charter, which is sort of promoting gender inclusive practices that people are signing up for with the idea in 2 years? I think something like that's very important. I mean, I think you need to be careful that it doesn't become a sort of ritualistic process. We all sign the charter, ergo we've done all we need to do, and let's just stop there. So I would encourage the Law Society to, you've helped clarify expectations, which is the responsibility side. Now we need the feedback and accountability side. So hopefully there'll be some reporting. There is a lot of reporting now about this in the press anyway. It's regularly reported what the representation of gender in different groups are in law firms and that. So it won't take long for some journalists to say, well, let's look at who signed the Law Society's charter and let's look at what they're doing. The charter's more about processes, which I think are very, very important as a sort of a push factor. So I think that's very good. I think recognising people who championing people, creating role models of women. That history of the Law Society, which I was in a former Chief Justice's office actually, and I saw it there, and I noticed it has a chapter on First for Women and things like that. And so I think. I mean, that was interesting to me because I've incorporated little bits of it into my. This idea that women weren't defined as people, when the first graduates came through. Sort of these just interesting historical facts about attitudes and how they sit in the unconscious biases and how they get institutionalized. So I think, you've got, for me, there's a lot of information contained within the Law Society that could be used to champion this, and just simply looking at how much change has occurred, and when we heard this one of the young lawyers and others speaking about, the blockchain and the technological change. I mean, it's just an inevitable fact, and so seeing this as just part of the overall change process, I think, is very, very important. And when you look at your history, you've done a lot, and I think we often don't use the history enough to promote what we're trying to do in the present. So, but I think the Charter and use of history are very good things. Yeah.
You talked about unconscious bias. What have been your observations about how law firms are dealing with unconscious bias, and are they dealing with it effectively?
Well, with this, we have a big research project around unconscious bias, and so we've been contracted and do a lot of work with law firms around unconscious bias, and I can tell you our approach to that. But let me first say, there is evidence that unconscious bias can make things worse rather than better. It's in a sense of, it's like saying to somebody, think outside the box. I mean, it's at one level, as a cognitive psychologist, I can tell you it's a silly statement because it's not something you can just force yourself to do. You need processes, you need systems, you need to create the space and time, and so the same is true about unconscious bias. You train people and they say, "Oh, yeah, I understand it. We're biased. We get it," and then they do nothing. It really comes down to systems and processes, and there's a couple of critical systems and processes. A lot of law firms, so what we will typically do is we'll talk to people about unconscious bias, and then we'll make the point about how it plays out in a client relationship. And if we were talking to a finance institution, we talk about how it impacts on your financial decision making, because unconscious thinking processes are part of our everyday life, right? And so it plays out in all our actions, and then we'll do a sort of a shift from talking about client relationships or judgments to unconscious bias as it relates to LBGTI or gender and the like. So then we say, okay, so what do you do about it? And ultimately you need to ground it in some simple action. One of the things about unconscious thought is it's highly efficient. It's all our expertise. It's everything. It's just mixed up with some things that don't have to be correct. I mean, if every time you made a biased judgment you got a 20 volt or 10 volt shock, you would stop really quickly. Unfortunately, the world is very forgiving, and so creating feedback loops and awareness is important. So when we speak to law firms, a lot is made about selection processes and promotion processes. And so we're currently running a large research project with the Victorian government on de-identification of people, the sort of in the process. That turns out to be much more difficult. It's easy to imagine, and everybody's heard the symphony example. You've heard where in the selection for symphonies in the 80s under equal employment opportunity in the US, some symphonies went to blind selection, and basically what happens is you play behind a gauze curtain and you take your shoes off so they don't know if you're male or female. And under that process, the number of females in symphonies, and I may get the years and the percentages right, but they're not big difference, in 5 years went from 7% to 23%, or in 7 years went from 5 to 23%, right? And the basic idea was once you took the image of the male or the female out, it made a difference. Unfortunately, the example for symphonies is easy. When you start thinking about the process of reviewing a partner and talking about, it's very difficult to take all that information out. But we've made the point, selection and promotion processes are very important, and there are all these issues about do women put themselves forward and all that. I actually think that there's a slightly more fundamental form of unconscious bias, and it's in work allocation processes. And so I think often women as senior associates get to the gate and they just don't look as good as the males, and the reason is a dynamic of work allocation. And so it may be, we're about to go out and there's a young female associate and a young male associate, and I'm about, I'm going to be out late at night, and so I say, I'm about to say to the young female associate, I'll grab your coat. And bouncing around the back of my mind is sort of, this sort of unconscious issues, young woman and stuff, and I may get into some protective tendencies. And I say, oh, how's the family and stuff? And then I say to the young man, grab your coat, we go out, we hit it off. We just, there's a natural affinity bias. He's interested in football, I'm interested in football, or whatever it is. And when I go home to my partner, I don't have the issue of saying I'm being out with a young female. Or, all these. I mean, these are things that these are just human nature, right? And then over time, I start to work with the young male. I give him work. He becomes more confident. He becomes my go-to person. The female becomes a safe pair of hands that I give. What you could call the pink files, the contract, it's in tax. He's with me when I'm negotiating with the ATO or trilateral negotiations, talking to major clients. Female is finishing off the contracts, and there's so these dependencies develop, one around a sort of low development trajectory and the other around a high development trajectory. And I often say to lawyers, who has a go-to person? And they all do, right? Okay, is it male or female? I have to say it's about 90% male. And then once you start that process, there's a whole range of unconscious biases, affinity biases, familiarity, social structure. There's just a lot of stuff that comes into play. And then 5 years later, they just look different. This person, I start to say, the young male, Bill or whatever, he's got initiative, he understands, he takes risks, and the young woman, Mary, she's a safe pair of hands, but, and then the worst situation is when the young woman starts to self-label. She starts to say, I don't really have the risk-taking, or, she starts using some attribution. Now, all that, and I've seen this many times in conversations, and then of course I'll start saying, well, Mary doesn't really want to put herself forward. But what's not obvious to us is the historical process that led to this and the part we play in it. Keep in mind, the two of them came in as graduates. Now, the selection processes for most law firms guarantee these people are, the only difference really is the gender. I mean, the pre-selection processes, the interviews and all that sort of stuff. So you've got these people who are basically, two human assets are the same. One gets developed through a set of unconsciously biased processes, the other gets less developed through the unconsciously biased processes, and then people start labelling it differently. And so I think that is a big issue, and it's one that's quite easily solved, right? So we now, in one of the law firms we deal with, we say, look, and of course the other thing is it starts to lead to differences in salary, and that trajectory comes over time. So I think rule number one is all graduates should be paid the same from the moment they walk in the door. That's rule number one. Rule number two is when you sit down, you have a list of your associates and senior associates, males and females, and every time you allocate a file, you classify it as developmental or routine. And it's a simple conscious record. Now, in the case of one of the accounting firms we deal with, they're trying to work through their timesheets to provide a report. It turns out, I've sort of been surprised about how easy it is potentially to solve this problem, though people can imagine barriers. If you simply go through and say, look, in this area, what are the 10 major tasks? And often it's not even 10, it's 5 or 6. Which are the more routine and which are the more developmental? Which are the ones that if I'm presenting to the partnership to become a partner, which are the ones that I need to have in addition to client, and what are the ones that are going to give me client contact? If you categorise those, if you've got a reasonably, if your pay allocation's based on timesheets, it shouldn't be too difficult to bundle those up and report them back. So Bill's had, 60% of Bill's time in the last month's been on developmental files, and 20% of Mary's has been on only 20% of Mary's. And those sorts of things, in the Aristotelian sense, you become what you do. So if you want to be virtuous, commit virtuous acts. If you want to become a partner, commit acts that look like a partnership. And so these are quite solvable problems of ways of getting around unconscious bias. The big barrier there is the quality of the timesheets reporting, I have to say. And it's nothing to do with dishonesty, it's just to do with lack of clear discrimination and things like that. But once again, there are other benefits. So it's the moment you start looking at this unconscious bias, it's more than just raising people's awareness. It's saying what are processes where it plays out and affects the differential thing. I don't think anybody's out to block. Well, I mean, there's probably a few, but the number of people who'd say consciously it's not women's work, I just think that's very small. I think a lot of these unconscious processes play out in opportunities and access, and development and the like.
Is the legal profession any different when it comes to these issues compared to other professions? I suppose the most obvious one would be accountants.
Yeah. It's a good question. When you look at partnerships and percentages, the number of incoming graduates, male, female, and the progression is very similar. And if you look across the big four accounting firms and the if you look across the accounting firms and the like, percentages are slightly higher in the accounting firms. Accounting firms are doing a lot more, and they're doing a lot more because they have something that law firms don't have. They typically have consulting wings, so diversity has become a business, a product for them. So they have an external product that they run and develop internally, whereas as a law firm, unless you're advising in that area, it's much more of an add-on, so it's not integral to your business. So the real issue will be, given this last 5 years, a big push around this, what happens in the next 5 years. Interestingly, despite large investments in what I call push strategies, that's mentoring, supply chain, trying to get more women job ready, being attentive to the work allocation process. And keep in mind, being attentive to the work allocation process takes a few years to, you don't become qualified to be a partner just because you suddenly got a few developmental opportunities this year. It's a 3, 4, 5, 6 year process, so that's going to take time to work through the system. And not all law firms are doing it as well. Individuals do it, but systematically. The accounting firms are, so we might see some of the accounting firms, the ones I've dealt with, but so I think the proof of the pudding will be in a few years. But what we have seen is a lot of these push strategies like the networking and mentoring haven't led to the change in the numbers that we might have expected. So then you start thinking about, and I think accounting firms have moved in this way, as some of the law firms, of what I would call pull strategies. So you've got supply strategies, creating a greater supply of women. One of the problems you have in law firms, and to a slightly lesser degree, but also in accounting firms, is you just can't go out and find alternative sources of supply. You have to have a degree, an honours degree. You have to have experience. So you can't do, for example, in institutional banking, you can go and recruit somebody who has no experience in institutional banking and train them in 2 or 3 months. If you're a Rio Tinto and you want to get more female machine operators, and there's not people out there with tickets, you recruit them without tickets, you train them over 3 or 4 months. They dig up a few gas pipes and stuff, but it's not major. With law firms, you've got what you got. You can't go and find alternative sources of supply, but there are a lot of female suppliers out there. So the supply side is sort of being, and it's just, I think the big issue is this work allocation. If people are getting the right work allocated and developing over time, and I also think if an individual, be it a female or somebody from LGBTI background, is getting the right work allocated and a sense of progressive mastery, it makes them quite resilient to many other attitudes. If you're not getting that and you've got negative attitudes about your fit, then it's more difficult. People who are being successful and feel like they're progressing are just much more resilient than people who feel like they're being sidelined and like. So in that sense, the question that's coming up, if these supply side or push strategies are not creating, getting enough women through the pipeline, then people are starting to look at pull strategies like demand side, like targets and quotas. And that's interesting because the moment you mention that, and this is more likely to be true in professional areas, people will talk about merit and say, well, if we have these targets and quotas, we're going to start selecting women of lesser merit and reverse discrimination. That assumes that the current process is full of merit, right? Which is not always the case. I mean, partners fail, and as do in all sorts of firms and that. But what I think is equally true is if you put targets and quotas in place, if the existing processes were delivering the desired outcomes, then we would see more women, right? So if you are going to put targets and quotas in place, they're only going to be effective if people think about new and different ways of doing things, like the work allocation or whatever the strategies are, and what are the range, what are the current constraints. There certainly are enough female lawyers out there to fill all the roles that we might want. The question is, how do they get through to the senior levels? I mean, it's not limited to the law firms. I just was recently talking to judges in Victoria, and they made the point about the bias in the briefing processes, which is the same thing,
yep.
right? And it's quite interesting. They made the point. This idea of the go-to person, where I go to the guy and it's one, they said it takes one briefing to develop a relationship and a dependency. And if your first instinct, so if I ask you, can you recommend somebody, and your unconscious network is all men, and you say, I'll go to so-and-so, if that person works the first time, and after 2 times, if they've been satisfactory, which is fine. I mean, it's not that if they're incompetent, there's no question. But if they're competent, the point is we're unconsciously discriminating against a potential female, and then of course that builds up over time. So it's a very quick exclusion that has long-run implications. So I think. It's just a lot of potential source of unconscious bias, I guess.
Thank you. Katie, any questions?
No more questions.
Professor, very much appreciated coming on.
I just want to make one final observation,
Please.
if I may, which this is something I've heard a lot about, the millennials. And the views tend to be they're not loyal, sometimes they're lazy, or they want to go on sabbaticals and all that. And it's quite an interesting phenomena because law firms like universities, the increasing corporatization has really led to in many places a disconnection from their deeper purpose. Their deeper purpose is around justice and serving society and all that. And clearly income and sustainability and all those things are very important, but the two can become disconnected. What we're seeing now with the millennials is that when they ask themselves, what's my purpose in life? It's that deeper purpose. It comes back to the sort of traditional notions of justice and serving. So what we're observing among millennials is an increasing preference for NGOs and other not-for-profit work and pro bono work and the like, and flexibility. And that's quite an interesting factor, because that in itself is the sort of a natural disruptor, just like technology. So these natural disruptions, you can lecture all you like about the need to change, but if necessity being the mother of invention, so what we're observing is some people are complaining about the millennials and saying, oh, they're this and that. Others are sort of taking it on board and saying, is this a new way of thinking about legal work? Is it a new way of thinking about who we are and what we do? And in a sense, in the true tradition of a natural law approach, going back to what's our deeper reason for what we're doing, which is sort of a question that I think the law asks itself all the time, and sort of law firms are going back to that and saying these millennials, and for some, are giving us a reason to rethink our purpose. And once you rethink that, you start rethinking how you might do it. So in that sense, there's sort of greater interest in flexibility and balance in life and all that. May be something that people are more amenable to than they have been in the past.
Maybe the millennials have a higher level of social consciousness than their predecessors.
Well, I think they're more conscious about it. Because when you look at law firms, I was at the Women of Influence last night, and Moya won the top Woman of Influence, and one of the points she made was Gilbert and Tobin give her time to pursue her extracurricular work and the like. So, and most of the law firms I've dealt with have a very strong social outreach and pro bono, but it's not as deeply integrated to their work and the way they think about themselves.